My Lords, EF 166, paragraph 141 of the judgment of Lord Justice Nugee, leading into his paragraph 142. In 141, the first point, it has always been the case that a purpose will only be charitable if it is for the public benefit. We entirely agree. The second point, there are two aspects to the requirement of public benefit, namely the nature of the purpose and the reach of the purpose, and in the present case we're concerned with the latter. My Lord, we agree that there are different aspects to the requirement of public benefit, but we think that the formulation thereafter, referring to both the nature of the purpose and the reach of the purpose, is rather to conflate purposes and activities in a way that should not be done, and which has the tendency to leave the public benefit out when considering the activities. The third point, based on the independent schools case, we do take issue with. My Lord, in fact, there is a printing error there. It's not paragraph 95 in the ISC case, it's paragraph 195. Paragraph 95's got nothing to do with this. My Lord, paragraph 195...
Yes, that's the one that caught my eye.
Yes. That is at EF 950 in the Independent Schools Council case. My Lord, we do take issue with in particular with the last sentence there, though depending to some extent on how one interprets the last sentence. But correspondingly, we part company with respect with Lord Justice Nugee in saying that in terms of public benefit, one is looking only at the activities as a whole, and we take issue with the tribunal in the independent schools case in saying that, or whatever it is precisely that it may be that it is.
Well, it's the bit where he says, in the case of a school which is a charity, the education of fee-paying students is nonetheless in fulfilment of the public benefit requirement. In other words, it's the education for all the students that fulfills the public benefit requirement, not just the poor ones.
That's what he seems to be saying.
Yes, but you take issue with that?
Yes.
Yes, I thought you did, but I thought I'd just raise it with you because I was banging on about it this morning without any reference, but this I think is the reference in question.
No, that does rather throw one off.
The number's wrong.
Of course. My Lord, nonetheless, the ISC case is just worth looking briefly earlier on in the judgment from paragraph 44 on the concept of public benefit, where the tribunal say the courts have adopted an incremental and somewhat ad hoc approach in relation to what benefits the community or a section of the community.
Can you give us a page for that?
908, my Lord.
Thank you.
908.
It says, third line into paragraph 44, there's never been an attempt comprehensively to define what is or is not of public benefit. It's possible, however, to discern from the cases two related aspects of public benefit. The first aspect is that the nature of the purpose itself must be such as to be a benefit to the community. That's public benefit in the first sense. In that sense, the advancement of education, referred to in the preamble to the 1601 Act, has the necessary element of benefit to the community, subject to qualification. The second aspect is that those who may benefit from the carrying out of the purpose must be sufficiently numerous and identified in such manner as to constitute what is described in the authorities as a section of the public, that is, public benefit in the second sense, and then observations which relate to education in particular. And then paragraph 45, one result of this ad hoc development is that what satisfies the public benefit requirement may differ markedly between different types of allegedly charitable purposes. That's why caution must be exercised in applying authorities decided in one area of charity to another law. Paragraph 46, another result of this ad hoc development is that the authorities do not provide a comprehensive statement of the elements of the public benefit requirement, but rather a series of examples of when the public benefit requirement is or is not satisfied. A distinction is not always drawn, and often did not need to be drawn, between the two senses of public benefit. Then on the next page, 910, para 48, a third result of the ad hoc development is that the relationship between the public benefit requirement as it came to be understood immediately before the 2006 Act, Charities Act, and the much earlier requirement that a gift could only be charitable if it fell within or within the spirit of the preamble is not entirely clear. And then finally on EF 911, beginning of paragraph 1, the development of a separately identified public benefit requirement seems to stem from the decision of the House of Lords.
I'm so sorry, where are you now?
My Lord, paragraph 51 on page EF 911.
Thank you.
Pencil.
The development of a separately identified public benefit requirement seems to stem from the decision of the House of Lords and Income Tax Commissioners and Pemsel in 1891. And then in 53, in summary, we conclude that in the state of the authorities immediately prior to the 2006 Act, public benefit, as that term was understood for the purpose of the law relating to charities, included both the aspects which we have identified at paragraph 44 above. Purpose had to be for the public benefit in both the first and second sense if it was to qualify as a charitable purpose.
Yeah.
But I think the tribunal, I think it's Mr. Justice Warren in this case,
yes,
is right, isn't he, by focusing on the way in which charities law developed, because of course you needed to be able to apply the public benefit test at the point where a gift or bequest was made, because if you didn't satisfy the charities test at that point, it would fail. It would be a purpose trust and would fail. So doesn't that indicate that the public benefit test is itself quite a high-level test to be applied to the purposes of the charity in a general sense, taken overall, rather than a test which is apt for application premises by premises, wherever the charity may happen at a particular time later on to carry out on its activities?
Well, my Lord, I would accept that to this extent, that public benefit is a broad concept which is capable of manifesting itself in many ways, and in that sense is a question to be addressed at a high level, but that it doesn't follow from that when one is talking about the rating of individual premises that it is otherwise than appropriate to look at public benefit, albeit in a broad rather than restrictive way, so far as those premises are concerned, and not so far as other premises elsewhere are concerned, and the question of exemption from rates of the occupiers of those premises.
Yes, thank you.
Thank you.
My Lord, drawing some threads together, I'd like to say a little, if I may, about alleged inconsistency of our case with charity law, if that would assist. My Lord, what we say so far as that is concerned is really in response to the Respondent's argument, as we understand it, that an hereditamment specific assessment of public benefit is inconsistent with charity law, because in charity law, public benefit is assessed across all the activities of the charity. I've already addressed that, of course. The question of whether the use of a particular property is inter vires the charity, that is, compatible with fiduciary duty on the one hand, and whether that property has an entitlement to mandatory rating relief on the other hand, are questions that may overlap, certainly, but in our submission they are certainly not identical. A finding, as in Oxfam, that premises are not eligible for rating relief does not require any finding of breach of statutory duty, and no one suggests that it does. So the public benefit requirement doesn't import through the meaning of charitable purposes any requirement that outside the context of whether or not there is a breach of fiduciary duty, the question whether the charity is operating for the public benefit must be assessed across all the charity's activities. Our submission, that is, does not follow, and mandatory relief is not available on the basis of all the lawful activities of a charity, but on the basis of a lawful activity at particular premises that either directly fulfills the charity's lawful purpose or is wholly ancillary to or directly facilitates charitable activity. In our context, a rating context, one is not looking at whether the charity is operating elsewhere for charitable purposes, but rather whether it is using these premises for charitable purposes in a way that justifies mandatory relief. And in our submission, there is no presumption that the charitable purposes that the respondent does have are presumptively for the public benefit in respect of all the properties it owns. Indeed, it is in our submission a big problem for the respondents to explain how a public benefit assessment of all the activities of a charity is to be factored into the use of each and every individual hereditament. What they contend for is, in effect, that all lawful charitable activity will qualify because all of a charity's activities must be in fulfilment of the charity's purposes. But this is entirely inconsistent with Oxfam and the need to assess whether an activity at premises is for the public benefit in order to assess whether it is an activity for the public benefit. So we say that an exemption for mandatory relief, what this case is about, can be achieved in either of two ways, neither of them applicable here. First, if the property in respect of which relief is claimed is charitable, that is, wholly or mainly for charitable purposes. Secondly, if the use of the property in respect of which relief is claimed is incidental or ancillary to such a purpose of the charity overall. And in our submission, on neither of those do they get home. My Lord, otherwise, we submit very briefly that there is nothing to be derived from the speech of Lord Guest in the Oxfam case. We're not seeking, rather in the, I think the earlier case, the Glasgow case, we're not seeking to resurrect that. Our position is not seeking to rely on Lord Guest in that case. Secondly, so far as legislative history is concerned, and in particular the Pritchard report, we submit that doesn't engage with the question of substantive legislative purpose in connection with the current legislation. The purpose was clearly to make some change of substance as well as to clear up procedure. And on an historical analysis, the respondent's approach doesn't engage with the statutory scheme as it now is, and in particular Section 45A of the 1988 Act, introduced later, which your lordships saw this morning, it would be extraordinary if that had a different meaning from section 43(6 when they adopt the same language in the same statute. Nor do we accept that our case is that the 2006 Rating Act changed charity law. That's not the way we put it. It's not the way that Lord Justice David Richards said. But the 2006 Act did articulate the public benefit requirement that had previously adopted, but was mainly dealing with other matters. My Lord, finally, on the generalities, the example of the 5 schools, one of which produces outreach work, that's paragraph 151 in Lord Justice News's judgment, so one would expect in such a case that the operation of the school would be directly incidental or ancillary to the conduct of the public benefit generating activities. In other words, that the situation would be on the right side of the line because it would be like the head office example would be capable of being. But one has to start with the charitable purposes and then look to see what functional link there is, if any, with the particular activity at the particular premises. Lord, finally, very briefly on issue 2 before your lordships.
Well, we're going to deal with that.
Deal with that at a later stage. Yes.
Obviously, it only arises if you're right on issue 1, I think.
Yes, issue 1 is what it's all about as far as we're concerned. We say if we're right on issue 1, we're not defeated by the, in effect, cross appeal, although it's not in that form.
Well, then we have to hear.
So we say the Court of Appeal was right on issue 2.
If you're right on issue 1, that gives rise to issue 2.
Yes, indeed.
Yes, but if you're wrong on issue 1, it doesn't.
Yeah.
Yes. Yes, thank you very much indeed, Mr. Gowdy. Now, Mr. Klinsky.
May it please your lordships, I'll deal obviously subject to the direction with only issue 1.
Yes.
And my overall time estimate was, I think, 3.5 hours. So I think 45 minutes of that is for issue 2. So
okay.
If that helps,
that does
just
help.
in terms
yes,
of where we are. In terms of the running order, obviously subject to the court's preferences and dealing with points that are of concern to the court as they arise, I was proposing to take the following course: to deal at the outset with some factual points which provide the evidential context for issue 1. I'll deal with that shortly as I can, but there are some references to the evidence that I'd like to take briefly. Then to deal with the statutory construction points on the words of the statute and also the relationship between the rating legislation and the Charity Act. Then I'm going to deal with the statutory history and in particular the Pritchard report, which I say is of assistance in understanding the mischief and the manner in which Parliament sought to address the mischief, and then deal with the key rating cases. I agree they are Glasgow and Oxfam, and I won't go over ground that Mr. Gowdy's dealt with, but I do want to show Lords those cases and make submissions in relation to them. And then fifthly, to deal with the implications, and sixthly, just to pick up any points that I haven't covered. So that's the course I'm intending to chart as efficiently as I can. In terms of the first section of the factual points, Mr. Newman, who was the Nuffield Health's General Counsel and Company Secretary, gave evidence by way of a witness statement which wasn't challenged, and the focus of that was the what Nuffield's charitable purposes are, and how the use of the Merton Abbey related to those charitable purposes. And I would like to just show the court a couple of extracts from those. So if we could pick it up at 226. Which is the front page of Mr. Newman's witness statements, and going over to 227, there's a section there, Nuffield Health's charitable objects and activities. And if I could just pick up paragraph 5, in the second sentence there, our mission is to help people live healthy lives, recover from ill health, and maintain their health and fitness. We do this by running a network of hospitals, medical centres, fitness and wellbeing centres like Merton Abbey and diagnostic units across the UK. He then sets out some points on the history of the charity, and if I could pick it up at paragraph 9, from the mid-2000s, the charity shifted its focus to prevention of illness as much as cure, and then he indicates that that was followed by a formal amendment of the charity's objects in 2010, and the relevant objects are there set out to advance, promote and maintain health and healthcare of all descriptions, and to prevent, relieve and cure sickness and ill health of every kind, all for the public benefit.
And that's run as a single overall charity?
Yes.
With these various
yes.
activities and objects?
Exactly. It's common ground that single overall charity is obviously a registered charity. That's clear. It's also recorded in the statement of facts and issues. The effect of registration, I say, is correctly identified in the majority judgment in the Court of Appeal, and it might just be convenient to remind the court of that at this moment. If I could go to 161. Paragraph 129. Where, and this is within the judgment of Lord Justice Nugee, an institution that's registered with the Charities Commission is by Section 37 of the 2011 Act conclusively presumed, save for the purpose of rectifying the register, to be a charity. Nuffield Health is on the register and so benefits from that presumption. Although there's no dispute about this, it's worth spelling out what this means. He then refers to the charity legislation and says that it follows that the effect of Section 37 is that Nuffield's purposes are conclusively presumed not only to fall within Section 3.1d, the court will recall seeing that early this morning, but to be for public benefit within the meaning of Section 4 and hence charitable. It is to be noted that because an institution can only be a charity if it's established for charitable purposes only, that all of its purposes are presumed to be charitable and hence both to be within Section 3.1 and for the public benefit. Now, my submission is that is a correct and uncontroversial analysis of the effect of Section 37. It doesn't... Sorry, my Lord.
It may not be uncontroversial.
I'm not saying it takes me to the end of the case.
I'm not sure that Mr. Gowdy would agree with it, with the last sentence.
Well, it's
I only raise it in case there's any other authority than the judgment being appealed that says the same thing.
Well, I will go to the... Yes, well, there is... Well, you've seen ISC on that, and I'll come back to that, because there's one other reference that I think helps on that. But may I come back to that? For present purposes, my submission is that's a correct analysis. If I could then go back to Mr. Newman at 228. And pick up his evidence at paragraph 11. He says it, by which he means Nuffield Health, aims to achieve those objects by maintaining a widely accessible health system, and I do emphasise this, which connects three key elements. Those elements are the promotion of fitness, emotional well-being and health education as a means of maintaining good health. So one element is maintaining good health. The other is the identification, assessment and containment of health risks. And the other is, so in other words, diagnosis. And the third element is the treatment of diagnosed problems, including rehabilitation following treatment. And to that end, Nuffield Health has established a network of fitness and wellbeing centres, diagnostic units, hospitals and health clinics, complemented by digital health and wellbeing services. Now, the reason I'm drawing that to your attention is that the evidence, which is unchallenged, is that the health and wellbeing centres are part of a connected network of achieving these connecting elements, and the sort of unique combination is the three elements of maintaining good health, identifying and assessing health, and treating health. And that's encapsulated in a diagram better than in words. If I could just go to invite the court to go to 474, which is a page taken from the 2016 annual report.
I do beg your pardon. Can you just give me the page again?
474, my lord.
Thank you. Yeah.
And that's the virtuous circle, if I can call it that, of treatment and recover, achieve and maintain, diagnose and monitor, reflects the reflects what Mr. Newman describes in his paragraph 11. And my lords, you'll see then the sort of various activities are characterised under those three headings, and all three headings are represented at Merton Abbey. So there's health assessment, which is from the diagnosis and monitor. There's physiotherapy, which is from the treat and recover. And obviously the primary focus is the achieve and maintain. But there is a footprint of each one of those interconnected elements at Merton Abbey. And Nuffield says in its annual report what we do, and I'm reading from just higher up the page of 474, through our experts, we link these sites and services up to offer connected healthcare provision from diagnosis through to treatment, recovery and maintenance. And so if I could then just go back, there's a similar diagram or a similar point in the 2017 report, which is 277. We don't need to go to it, but in case it's helpful just to give that reference. And then if I could go back to Mr. Newman's evidence at 228, paragraph 15. He has a heading above paragraph 15, above paragraph 14 of delivering public benefit. Now, I say at once, this is across the whole of the charity. Mr. Newman's evidence was about the whole of the charity. There was also an evidence from Mr. Platt that dealt specifically with the site, but this is relevant to issue 1, the position across the whole of the activity, the whole of the charity, and it says the primary means by which the charity seeks to deliver public benefits through the core trading activities undertaken at its hospitals, clinics, fitness and wellbeing centres. The fitness and wellbeing centres, such as Merton Abbey, provide conventional gym equipment, personal training and exercise classes, as well as a range of other health-related benefits such as health checks, screening, weight loss programmes, physiotherapy, nutritional therapy, emotional wellbeing advice, mental health treatment and health education events. Given the known benefits of physical activity in improving physical health and mental well-being, the use of the gym and pool facilities by people directly fulfills the charity's objects. That's the way the charity describes what it is doing at Merton Abbey. And then there's evidence about charity-wide initiatives in terms of creating services free of charge and at reduced rates at paragraph 17, and then what are described as other programmes, including Pathfinder initiatives at paragraph 18, which is at 103 and following. Just for example, a pioneering Pathfinder programme in relation to cystic fibrosis, giving free personal exercise and training and access to its facilities for those being treated at Great Ormond Street for cystic fibrosis. Now, I don't say that particular initiative happened at Merton Abbey, but that's part and parcel of the evidence as to how Nuffield is operating to achieve its objects. And Mr. Newman also explains in his evidence the process of monitoring and trustee review, and that is set out in paragraphs 9.
There's no dispute about any of this.
No, there isn't, and in fact it goes further than that. There's an express finding of the first instance judge that hasn't been appealed. So that's where I was going to go with that. So, my lord, but that's the factual context in which the construction argument is evaluated, but also insofar as a submission is made that there's no functional connection.
Well, point number one is a pure point of law.
Yes, it is informed by the factual context, but
I don't think it's informed by that at all. It has to be applied, whatever the factual context might be.
My lord, that's certainly. That's certainly right. There are statements in Rossendale, for example, of the factual context. But the only reason I'm actually taking you to these, and I've nearly finished, but the only reason is the submission was made that there's no functional connection between the use of Merton Abbey and the activities on the other site. And actually, as a matter of evidence, that submission is wrong. The evidence was that there was...
It shows it's not an investment or a fundraising operation.
Yeah, and it shows that it's the way in which it delivers the objects, and I'll come on to the legal points that arise from that. But, my lord, yes, absolutely, that's right. And so just 2 points on that, just to tie together the nature of the litigation. As my Lord Legate observes, this isn't in dispute. I say more so, there's an express finding in paragraph 39 by the judge that we do deliver public benefit across the whole activity. So I wonder if I may just show the court that, because I'm not sure whether that's specifically in mind. That's the first point. And then I'll just go to that point now, and then so that is at 185. At 185, paragraph 39, the first instance judge says, based on what is stated in paragraphs 14 to 18 of Mr. Newman's first statement and the reviews carried out by its trustees, who are well aware of the legal requirements under which the charity is operated, as illustrated by its delivering public benefit policy document, there is no basis for any suggestion that the activities overall of the claimant are not for the public benefit. And that finding wasn't the subject of any appeal to the Court of Appeal.
But it's presumed, isn't it?
Well, it is. It's well.
For as long as yes. Nuffield remains registered as a charity, then it's presumed that it's carrying out overall
yes.
a function which serves the public benefit.
Yes, my lord, I certainly.
Well, certainly for my.
Probably why the judge used the elegant double negative.
For my part, certainly it's helpful to have a picture of an arrangement which you say is perhaps characteristic of charities operating in this area.
Forgive me, my lord.
Well, certainly for my purposes, it's helpful to have a picture of how you say your charity operates, and it may be illustrative of how other charities may operate in this area.
And may I just check what my lord means by this area as a health charity?
Yes.
So we say that our purposes are the advancement of health for public benefit.
Yes.
The activities that give effect to those objects are national. They are an interconnected network of facilities which cover treatment, monitoring and diagnosis in a holistic and interconnected way. And that, we say, Merton Abbey is part of that. It is occupied and used for the advancement of those purposes directly, and that is charitable because our purposes are conclusively presumed to be charitable, and we have demonstrated to the court that our activities overall are conducted for public benefit. And the second point that I wanted to say was that the fundraising point was live in the litigation below. It was dealt with, at first instance, and it was a subject to an appeal that failed, and it didn't come further. So there was an argument at first instance. It was one of the main points based on a case that isn't before my lords of RSPB, where that was a case, a first instance case, but it was on the back of the general rule in Oxfam that a charity shop isn't charitable, but for the legislative change that I'll come to just for clarity. But the general rule is a charity shop is on the wrong side of the line. In RSPB, the situation was that it was a shop selling gifts, but there was also it was said that there was some promotion of interest in birds by RSPB, and at first instance judgment there was an inquiry as to which was the main the main of those purposes, and unsurprisingly, given that the character of it was essentially a retail shop, that lost. Now that was relied upon in these proceedings below by Merton. They failed at first instance, they failed on appeal, and that's not before this court on appeal. So those are the facts taken as shortly as I can. May I then move to the statutory construction question? And I readily accept that the starting point of the inquiry has to be the words of the statute, and it's in particular it's the interrelationship of Section 43 of the rating legislation, the 1988 Local Government Finance Act, with the Charities Act, and to what extent and in what manner is a public benefit requirement imported into the rating legislation or implicit within the rating legislation by either the Charity Act or the general position in charity law. And I will come to those points. In the Court of Appeal, there were two basic approaches. The approach of the majority was to accept that the language was capable of more than one meaning, and that's encapsulated in particular in Lord Justice Nugie's judgment at paragraph 130, and the two meanings are what we say, is it being used for one of its purposes, i.e. the purposes of the charity, or is it being used in a way that, taken by itself, would be a charitable purpose capable of being registered as a freestanding charity. Those are the two alternatives that the majority say are both plausible alternatives on purely the language, and then there's a discussion of which one is closer to the language and how does the background material and the case law support that. Now, I accept that, but there's more than one way of reading this. I accept that what Merton say is one of the possible meanings. I say that the more you look at it, the less plausible it is and the more problems it would cause, but I accept that purely as a matter of language, it is one of the readings. The minority view of Lord Justice David Richards was that there was only one meaning, that there was only one possibility on the language, and that there was a clear answer. And I say that's wrong, both for the reasons I've given and for the reasons I'm going to develop for the rest of the afternoon and possibly into tomorrow. But I also say that actually the logic doesn't actually stand up on its own terms, because what he does is he uses the Charity Act to import into the rating test an approach to public benefit that's actually inconsistent with the approach to public benefit in charity law, and he does it through the wording of the 2011 Act. The change came in 2006, as Mr. Gowdy said, and it was consolidated in 2011, but he uses the language of the 2011 Act to indicate that that's the right approach, but without acknowledging that Section 4.3 of the 2011 Act says that public benefit has to have the meaning as understood in charity law. So I say it's actually illogical to import into the rating legislation through the prism of a statutory construction based on bringing something in from the Charities Act, when what you're actually bringing in is different from and inconsistent with the understanding of that term in charity law. I say there's an internal inconsistency there in that reasoning, and that reasoning is in paragraph 37 of the Court of Appeal's judgment. Forgive me, of Lord Justice David Richards, as he then was, as judgment. And the reason that I say, may I just show my lords the statutory provisions that go to that point, or so just revisit them with that point in mind. So, section 43.6 is at 380. Sorry, is at 680.
Yeah.
So so on the day concerned, the ratepayer is a charity or trustees for a charity, and the hereditament is wholly or mainly used for charitable purposes, whether of that charity or of that charity and other charities. So silent on the notion of public benefit on the face of the statute. Lord Justice David Richards says correctly that under section 1, so if you go to 665.
Is this a page number?
Yes, sorry. So we're going now to charity legislation, forgive me. Page 665, the meaning of charity, established for charitable purposes only. Section 2(1)(b), charitable purpose is a purpose which is for the public benefit, and I acknowledge that any reference in any subsection 2, any reference in any enactment or document in whatever terms to charitable purposes is to be read in accordance with that section, unless the context otherwise requires. I don't make a case that the context otherwise requires. The point is about how you read it in, and then, but the subsection 4 tells us that the public benefit requirement means that the purpose falling within 3(1) must be for the public benefit if it's to be a charitable purpose. And subsection 3 says in this chapter any reference to public benefit is a reference to the public benefit as that term is understood for the purpose of the law relating to charities in England and Wales. So my point is, how is public benefit understood in charity law? Well, it relates to purposes. We know separately that we've got the conclusive presumption in relation to purposes from section 37. It's assessed by the Charity Commission, in fact, at the point of registration and subject to scrutiny in terms of continuing registration. How is it assessed? It's assessed by reference to the activities of the charity as a whole. It's not logical, I say, to change the meaning of the public benefit concept and bring it into the rating legislation through a prism of saying you read it together with section 2 of the 2011 Charities Act if you're not also acknowledging as part of your construction the injunction in 4.3 to in essence be consistent with charity law in the meaning you attach to public benefits.
And just on that, you say it's assessed by the Charities Commission at the point of registration. I mean, section 4.3 goes back before the Charities Commission existed. The Charities Commission is now, I accept, is applying charities law. But, I mean, before the Charities Commission existed, as I think I was putting to Mr. Gowdy, it would be possible, indeed necessary in many cases, for a court to test whether a particular bequest or gift was for a charitable purpose, but if it wasn't, it would fail as a purpose trust.
Yes.
And so I just mention it because it seems to me that Section 4.3 takes one back to case law well before the Charities Commission came into existence.
Yes, I certainly accept that. I certainly accept and submit that the legislation in this regard doesn't change the law. It's in substance confirmatory, and that's analysed in detail in the Independent Schools Council case, and they go through it in detail. And in effect, they continually come back to the proposition that the legislation hasn't actually changed the common law. In relation to my Lord Sales's observation, I fully accept that. And when we look at Pritchard, we will see how the Pritchard Committee was anticipating the benefits in terms of simplicity and administration of relief of registration as taking one a very long way. Now, again, to jump forward on the argument, I don't say intra vires is all I need. I don't say that, but I do say that I get a long way from the registration and from the unchallenged evidence and finding that we are, in fact, acting for the public benefit across the totality of our activities.
And, I think the other point, just to emphasise it, if I may, and for your comment if you want to, is that whether one's looking at the Charity Commission applying the test or previously the courts applying the test, it was a test that was being applied prospectively. So at the point where typically you would have the trust instrument which set out certain objects, and the relevant test, whether those were charitable, had to be capable of being answered at that point, because, as I say, otherwise the gift would fail.
My Lord, I accept that. The Independent Schools Council decision deals with, if you like, the point for new charities and existing charities, and it creates an expectation of ongoing monitoring of conformity.
But the general thrust of the ICS decision is that you look at the constitution of the body which you're asking whether it's charitable or not.
Yes, and that you judge whether and how public benefit is delivered at the stage that we're discussing based on the Constitution, absolutely. Yeah. And then in terms of the ongoing monitoring of that, the expectation is that the activities as a whole will be carried out for the public benefit. And on that point, and I hope it's helpful to try and deal with it now, Mr. Gowden took you to paragraph 195 of the Independent Schools Council case, and that is the answer to the point that my Lord Bridge was raising about what is the position in relation to the full fee paying members of a school that does enough public benefit. The answer is that is part of the public benefit. That's very clearly stated in the passage that my Lord Briggs identified from 195, which is at 950. There's one other reference that also goes back to
just
that.
1 minute. 195 at 950.
So, so 950, paragraph 195, and the relevant passage is, if I could pick it up halfway through, so it's just above letter G. In the case of an existing charity, the inquiry is whether the activities overall are for the public benefit. In the case of a school which is a charity and is operating in accordance with the public interest, I think that's meant to be the public benefit requirement rather than the public interest. The provision of education to all of its students, including those who pay full fees, is carried out as part of this public benefit requirement. So that there's a clear statement that the education of the fee-paying students, provided that there's sufficient public benefit, is itself part of the public benefit delivery in the public benefit.
He repeats that in the last 3 lines.
It does, although the last 3 lines are that is
I'm not quite
how
sure
I
the
read.
last line is.
I find it quite hard to understand that.
But the
viewers do not satisfy that requirement.
Yes, the way that I've tried to understand that last line, which I have puzzled over, is not. I think it's nonetheless the partial fulfilment of the public benefit requirement. So, in other words, the education of the fee-paying students is part of the public benefit, but if that's all there is, that's a partial fulfilment. But if, as a whole, it's satisfied, then that's part of the public benefit.
So if you have a class of 20 students in an independent school and 5 are on bursaries, all 20 are getting a charitable education.
Exactly, and that's made much of, and the reason I think that I suggest my Lords might be assisted by a further reference is the bit of 195 I've taken to you two is clear. That last paragraph isn't the clearest paragraph in this decision, but actually you get the same point spelled out really clearly at paragraph 229, and that starts at 959, but actually if you go to 960, at letter D, this is discussing how high the threshold is, and just above letter D there's reference to it's necessary that there must be more than de minimis or token benefit for the poor. Once that low threshold is reached, what the trustees decide to do in the running of the school is a matter for them, subject to acting within the range within which reasonable trustees can properly act. That is something entirely different from imposing on the trustees the view of anyone else about what is reasonable. Now, pausing there, that was because the guidance that was being reviewed was saying the trustees' approach had to be reasonable, and the tribunal said, no, that's wrong as a matter of law. But then this is the bit that helps piece together the answer to my Lord Bridges proposition. In some circumstances, it may be that the trustees would be acting properly if they provided a quite modest benefit for the poor in excess of the de minimis level. The public benefit requirements applicable to the school would then be fulfilled, and in that context, we repeat, the provision of education to the full fee-paying students is itself for the public benefit, and that bit is absolutely unequivocal, even if there's any equivocation in paragraph 195, which I think properly read there isn't.
But if that's right, how is there any escape from the conclusion under the section 43 that the provision of gym facilities for full fee-paying members is in part is the discharge of a charitable purpose?
Well, that in my submission is that's right.
I mean, however you construe it.
You under charity, as I understand it, under charity law, that is right, and actually conceded by the appellant to be right, because paragraphs 26 to 28 of their case set out in terms that in relation to a multi-site charity, they expressly accept there's no requirement to deliver public benefit at each site. It's a matter overall. So if that's right, and the delivery of that is for public benefit as understood by charity, then there is no escape from the proposition in relation to a single private school that the delivery of fee-paying the delivery of fee-paying education, subject to there being enough public benefit, is all for the public benefit. I say it's a very small step, and it's a step that's impossible to resist in these circumstances. If, as on the unchallenged findings is the case, overall, Nuffield House is registered a charity and its purposes are for public benefit. Overall, there's an express finding, if there needs to be, that its activities overall are for the charitable, are for the public benefit. That being the case, it factually being the case that in the real world, Nuffield Health operates from multiple premises rather than just one. The provision on one of its premises to fee-paying members of services which assist their either the maintenance, the treatment, or the diagnosis of health is for the public benefit. And therefore, even if my learned friend is right that the inquiry is the public benefit delivered from the hereditament, and I don't think there's actually much between us on that, because once you understand that properly, that formulation is satisfied on a proper understanding of charity law. So,
and just before we leave the ISC case, I was looking at paragraph 194 because we were on that page 950, and it seemed to me that was again indicative of the way in which the courts would control what a charity did by looking at its objects, construing them, if they were to be charitable, as incorporating a general public benefit test. And then if the charity trustees didn't act accordingly, they would be compelled to act in accordance with the objects, but those would be the objects as laid down in the charity's constitution. And so it's the objects in the constitution which one is testing to see whether they satisfy the public benefits test, not individual activities, activity by activity.
My Lord, that's absolutely right, I submit, and I think, although there was some difference of agreement in one of the cases, that Lord Denning suggested that you could look at what happened to understand the purposes, but the orthodoxy and the majority was no. You look at the you look at the Constitution to understand the object. So that's consistent with the formulation that my Lord Sales put to me.
Mr. Justice Warren doesn't spell it out, but the reason why that's so is presumably because the full fee paying their students, here members, are part of the relevant section of the public, even if they're not the whole of it.
My Lord, yes, that we accept that.
And I'm not sure one ever quite sees that spelled out anywhere, but I'm struggling to think of any other explanation.
Yes, it's because and that must be so, because it's a requirement not to exclude the poor rather than a requirement to do only for the poor.
Yes, it's not a charity for the relief of the poor.
Yes. No, absolutely, and that is that principle doesn't emerge perhaps clearly enough from ISC, but I submit it's entirely consistent with what ISC says.
I mean, I was having a quick look at the Oppenheim case from 1951 appeal cases, which I don't think we've got in our bundle, but there is quite a lot of discussion of what the public benefit test means there, and there's some discussion of that was to do with an educational trust,
yes.
Trust for the education of the employees of British American Tobacco,
yes.
which failed. But there's a discussion there as to what would be expected to be required by way of public benefit in an educational trust case. Sorry, I just mentioned it.
Thank you, my Lord. So on the competing constructions, if I could just draw together four points, and I'm going to develop a couple of these, but I say that the rating approach to public benefit and the charity approach to public benefit should, as a matter of principle, be consistent. It would be surprising if public benefit meant something different in a rating context to what it means in a charities context. I say, for the reasons I've set out, that with respect, Lord Justice David Richards' analysis, as he then was, is internally inconsistent because it doesn't recognise the injunction in section 4.3 of the Charity Act that public benefit has the meaning attached to it in charity law, and he expressly brings in a different meaning in the rating legislation. He says he's compelled to do that by the clear wording. I say he isn't, and if we're in the territory of choosing between competing constructions, there's a whole host of reasons why that wouldn't be the more attractive of the two. And then I say, just to foreshadow where I'm now going, that the approach of introducing a hereditament-specific variant of the public benefit requirement is at odds with the aims and purpose of mandatory charitable relief, and I just identify two. One is the benefits of simplicity and ease of administration, and the second is actually there was an express discussion when the terms of mandatory relief were being thought about the benefits of aligning charity law with rating law rather than creating a distinct species of charity law applicable to rating law. And then the fourth point is actually it contradicts the settled approach in Oxfam and Glasgow to evaluate the use of the property on what I will call a counterfactual proposition of treating the occupying charity as if it were a different one hereditament charity. That's not the facts. The facts are the occupying charity is Nuffield Health. It has its objects and it carries out its activities in a certain way. And yes, you need to focus and understand the use it makes of the hereditament, but there's absolutely no imperative to do that in a counterfactual world as if it were one charity, rather than understanding it in the real world, where it's actually delivering public benefit across the totality of its activities in the fulfilment of its objects in the manner described by Mr. Newman in his unchallenged evidence.
I suppose you'd say in Glasgow it requires you to look at the house as if that was the only relevant piece of charity land.
Yes, what I will say.
Ignore the church next door.
No, exactly. The whole thrust. There's, I'll show you the way that it was put in argument in Oxfam. But the point is that there are two extremes, neither of which is right. Either all you need to show is a charity that occupies. That's not right. The test is more nuanced than that, and of course it is, and that's what Oxfam says, and we need to understand that. But the other is that you put the blinkers on, you draw a sharp line around the hereditament, and you only concern yourself with what happens there, and you view it in isolation. And that's contrary to the whole thrust of Glasgow and Oxfam. So, my lords, may I go next then to the statutory history and the Pritchard report, which you've not yet been taken to. So, in terms of the statutory history, I can just give you the essential summary by reference to the written case. So, it's our written case, paragraphs 13 to 19, which is at page 93 of the bundle, and the short highlights are that before 1955 there was no statutory provision dealing with charities generally in terms of rating relief, and what there was piecemeal concessionary practices happening in different local authorities. And this was becoming a problem, or coming to a head as a problem, because the 1948 Local Government Act basically centralised the exercise of valuation so that there was going to be uniformity of assessments, now known as rateable values, conducted by a central entity, the Board of the Inland Revenue. And this was going to take effect for the first time in the 1956 valuation list. So to meet the problem of how do you protect the charities from a new world where actually their properties are going to be valued based on their proper rateable value rather than the concessionary practices, there was the enactment of the 1955 Act, which was on its face a holding provision freezing the amount that existing charities could be charged by reference to what they were charged previously for a 3-year period that could then be extended by notice. And in the meantime, there was an inquiry set up under the chairmanship of Sir Fred Pritchard, a retired High Court judge, to report on recommendations for the future. And the story then is the Pritchard report reported, that was enacted with one exception under as the 1961 legislation, section 11, and that's then been reenacted since on 2 occasions under the General Rate Act, section 40, which was a pure consolidating provision, and then in 1988 under the Local Government Finance Act of 1988, where the test for our purposes didn't change, but actually the reach of relief in monetary terms changed. It went from 50% to 80% in 1988. But it did so without changing the essential test. So there's a direct line from Pritchard to the 61 Act to the statutory provision with which we're concerned, which is why I say that looking at the Pritchard report illuminates both the mischief and the method which Parliament adopted to meet the mischief. And that is a relevant aid to construction to the 1961 Act. And as the provisions haven't changed, the working assumption should be that they were reenacted for the same reasons, unless there's any indication to the contrary. So, with that introduction, may I take the court to the Pritchard Committee report. Just for your reference, I've tried to collect together a summary of the key points in paragraphs 20 to 22 of the written case, which is at 95 to 96, but it may be of some use just to look at the report in the original briefly, just to see what, if any, clues it might give as to the as to which of the competing approaches is more consistent with the statutory intention. So the report itself is at 1139, and the terms of reference are at in paragraph 1 at 1143. And the relevant point to note is that they exclude what was Section 7 of the Rating and Valuation Act, miscellaneous provisions, which is the religious exemption. So the treatment of religious buildings was carved out of the Pritchard terms of reference. We then have a useful historic survey between pages 1144 and 1156, and I won't take time on those, but there is a pithy but detailed analysis of the history, and we pick up then the 1955 Act at paragraph 47 at 1156, and there's a discussion of the terms of the 1955 Act, and at paragraph 52 on 1158, the Pritchard report draws together the following points. Three facts of some importance stand out from this brief account of the bill through Parliament. This is the 1955 Act. First, it provided the first statutory relief from rates for charities as such, and the first endorsement by Parliament of the reliefs previously given extra statutorily by local government in various forms. Second, the element of mandatory relief was introduced by the government, not initially as a matter of government policy, but in deference to the wishes of the House of Commons, after a provision relying entirely upon local discretion had been criticised from all quarters. So I spared my laws of detail of that, but Parliament ended up in mandatory territory in the 1955 Act, but it wasn't there to start with. And thirdly, this particular enactment was designed as a holding provision and was never intended to be a permanent arrangement. So that's the context of the 1955 Act. And then the conclusions about the 1955 Act. There's a section at 1160, the Section 8 of the 1955 Act, in operation, and there's a discussion of that, but where we get to paragraph 64 at 1162, viewed as a holding provision, Section 8 appears to have worked reasonably well, although unfortunately has given rise to a disproportionate volume of litigation. As a permanent solution, it would be indefensible, or as such it is devoid of both principle and logic. And then we have the main thrust of the report, recommendations for the future, starting at paragraph 65. And paragraph 65 notes that the rating system is described as a patchwork system. That's 5 lines down in paragraph 65. And and in the last sentence there, we see the way Pritchard approached it. We think it's impractical to eliminate all elements of arbitrariness in considering charities and kindred bodies. Our object has been to find a reasonable balance of conflicting arguments and interests, consistent with simplicity, certainty, and economy in administration. And we'll see that those thoughts, those objectives recur in the report. It then surveys various arguments advanced by charities and local authorities, and if I could pick it up at paragraph 74, at paragraph 83, 1166, there's a heading there, mandatory or discretionary relief, and at paragraph 88, we get the approach summarised at the bottom of the page 1167, within paragraph 88, we think the time has come to introduce a measure of uniformity and certainty into the rating reliefs enjoyed by bodies within our terms of reference. A satisfactory scheme should be simple and economic to administer and should not add materially to the rates borne by other classes of ratepayer. In our view, the essential basis should be mandatory relief for the great majority of the classes of organisations which have in the past enjoyed some measure of relief. And then the next heading is the field for mandatory relief, in other words, the parameters. And the key points here that I would draw to the court's attention is at 91 there is an approach that has been described in a contemporaneous academic review as robust realism. We think it's plain, however the field is defined, the results will be to some extent arbitrary, and the solution we have proposed is the arbitrary one of giving mandatory relief to charities. And then at 92, it expressly indicates this solution may admit to relief a number of bodies which are not particularly in need or deserving of relief, the sort of body which the man in the street would not ordinarily, in his view, the man in the street would not ordinarily, in the view of some of our local government witnesses, regard as charitable. We do not think this result can be avoided. It's doubtful whether there would be even near unanimity amongst the general public as to the charities to which privileges of charitable status should be denied, but even if there were, we can see no justification in principle for redefining the term charity for rating purposes. If charity is to be given some new statutory meaning, the new definition should apply equally for all purposes. So that's one of the references of effectively rejecting a bespoke approach to charity within the mandatory rating relief. At 93, they're looking ahead to the then proposed registration of charities, and as I understand it, that took effect in the 1960 Charity Act. This is written in 1959, and it says this proposal makes an important practical contribution to the ease and simplicity of administration.
So which paragraph was... Oh, I've got it.
93.
Yes.
Does my Lord see?
94.
You accept that proposal was not exactly accepted?
The proposal for...
Making registration conclusive as to entitlement to mandatory rating relief.
That's not what followed. We'll have to see other. But I certainly accept that is not what Section 43 as it now is does. I readily accept that. What I do say is instructive here is that the idea that registration is a simplifying factor and alignment with registration will be make an important practical contribution to ease and simplicity. But at this point, he's only looking ahead to it because registration isn't there. So my submission is that isn't a proposal of Pritchard. It's a sort of the complete alignment with registration isn't actually a specific proposal of Pritchard. But what he's saying is there will be registration that will very much help to simplify, and that would make an important practical contribution to ease and simplicity of administration. That's as far as I put it, my Lord. So I accept my Lord's point that isn't the test that results from this.
And one might think that the key point is paragraph 92, which you showed us that what's being proposed is that the rating regime will follow the charities law.
Yes, and that is absolutely a key point, my Lord. And we then the closest clue, just to pick up on my Lord Legate's point, that the closest clue we get to the actual test is 95. So relief which is the only bit that really deals with the nature of how an individual hereditament is occupied or used, is dealt with, and he says relief should be given only in respect of those hereditaments which are occupied for the purposes of the charity, and not, for example, in respect of hereditaments held as an investment. So the test is formulated in terms of occupation for the purposes. Now, I accept that when it gets enacted, occupation becomes use, and in other cases that distinction has become quite important. But the basic thought is it serving the purpose of the charity, as opposed to, one might say directly, as opposed to being held for an investment. And as it happens, I say that's really quite close to where Lord Cross in Oxfam draws the line, apparently without reference to this material, but happily in a way that's entirely consistent with this material. So that's paragraph 95. And then also on the point of should there be some kind of carve-out from charity law or special rules, there's paragraphs 96 to 99, where effectively 96 there's a discussion of, well, how do we treat national charities? Should we have a different approach to them because their benefits are not, they're serving more than a local need? And the answer is no, we shouldn't do that. There should be no exception for national rather than local. 97, mainly because of the practical difficulties in defining and identifying the bodies which would be excluded from relief on these grounds. We are unable to accept this view. The difficulties we believe to be very considerable. How, for instance, in view of the enormous variety of charitable activity for the public good, are benefits to the local rating area to be defined and measured? Who is to do the assessment? If a local charity should benefit one person outside the area of the rating authority, is it thereby to be excluded from rating relief? How is one to treat a national organisation which benefits a local area as well as farther afield? In our opinion, any attempt to separate charities of purely local benefit from others would lead to absurdities in practice and would go far to defeat the simplicity and certainty in administration. It would in practice be more trouble than it's worth. And again, there's then there's a discussion of yes, 98 is those which are not dependent on voluntary contributions. And again, that's rejected as a special category. Here again, quite apart from the merits, the practical difficulties are considerable. And so at 99, we have little difficulty, so that's at 1171, we have little difficulty in agreeing that with regard to charities in general, there should be no exclusion from relief on the ground that the body is national, or on the ground that it is in receipt of exchequer grant or fees, or because its voluntary income is small. There's then a discussion of universities, which we don't need to concern ourselves with, save just to identify this point. Pritchard, consistent with simplicity, thought that all universities should be subject to mandatory charitable relief. In fact, when the 1961 Act was enacted, that wasn't the case. That was the identified departure from Pritchard, which was that most universities were covered, but grant-maintained universities were carved out under the 1961 Act, which is Schedule 1. And I only draw that attention because that's the one area where Pritchard wasn't followed. But the basic position is, apart from that, Parliament thought they were effectively giving effect to the Pritchard Committee recommendations. And just finally, if one goes to 1184, there's a very helpful summary of the recommendations. And the points I would just draw attention to is that you can see here the recurring references to simplicity, ease of administration and certainty at, for example, subparagraphs 8, 12, 19 and 29, and at 15, which is at 1186, there's a clear statement that we'd already seen from paragraph 92. There is no justification for redefining the term charity for rating purposes only. So the conclusions that I suggest can be drawn from this background material are 4 points. Firstly, that charities should have a generally applicable concessionary regime. Secondly, that the intention was that relief aligns with rather than departs from charity law. And we see that in the definition of charity, in the rejection of carve-outs, and in the anticipation of a measure of alignment with and reliance upon registration. Thirdly, that the relief should be simple, easy to administer and certain. And fourthly, that the essential distinction contemplated was between occupation by charity for its purposes rather than holding property as an investment. So, my Lord, I respectfully adopt Lord Justice Peter Jackson's observation that paragraph 104, that the Pritchard report helps to understand the parliamentary intention lying behind the legislation. As I've indicated, it gives us strong clues as to the mischief, in other words, lack of consistency, piecemeal set of provisions, and the proposed solution. Keep it as simple as possible and align it with the understanding of charity law rather than create a bespoke approach for rating law. So, my Lords, I then move on to my 4th main heading, which is the key rating cases, Glasgow and Oxford. And what I do say is at the outset, and I'll go to them in turn in a moment, but at the moment I accept that they don't provide a definitive answer to what Justice Peter Jackson called the curiously unprecedented central question. But I say they do provide strong pointers, and there are 3 points that I identify. Firstly, that the law has in fact developed in a way which is consistent with the essential distinction foreshadowed in paragraph 95 of the Pritchard Committee. Secondly, that the key task is to understand how the occupying charity uses the hereditament to further its charitable purposes. And thirdly, the nature of the inquiry is not limited to what happens on the site, but permits an evaluation of what is happening on the site in relation to the overall activities and certainly the purposes of the charity in question. In other words, a real-world investigation as to how the charity uses the site to further its charitable purposes. So those are the essential points that I say are supported by authorities. May I go first to Glasgow, which is the first in time. I appreciate my Lords have been shown some of this already. Glasgow is at 787. And you'll recall from Mr. Gowdy's submissions that it concerns the provision in the Scottish legislation, the 1962 Act, which is in materially identical terms in terms of the governing concept of wholly or mainly used for charitable purposes. The facts are simple, and you've already been taken to them. You'll recall it's the occupation by the caretaker of the separately identified part of a single building, the caretaker's house, and which was within the church premises, but a distinct hereditament in the rating list. And you'll recall that there were two issues, 796 from the speech of Lord Reid, who is in occupation, and so that's 796 at letter C, who is in occupation, and if it's the church, whether the caretaker's house is wholly or mainly used for charitable purposes. We're obviously concerned only with that second issue, and so if I could just pick it up at 799 within the leading speech of Lord Reid, and at the foot of the page, he says, the appellants contend that it was used as a residence and for no other purpose, but once the respondents have been held to be the occupier, I think it's their use of the premises which we must consider. They used the house to have a servant on the spot to assist them in the more efficient performance of their charitable activities. I think that it is much too narrow a view simply to see whether any charitable activity is being carried on in the house. And he then gives the hospital example. I cannot think that it would be right, or that it was the intention of the Act to draw a line between the wards where they performed their charitable functions of nursing the sick and the places where they eat, rest and sleep. The efficient performance of their charitable function depends on their being properly cared for when they are off duty, and so caring for them appears to me to be wholly ancillary to the charitable purpose of the hospital. But there is nothing to prevent a charitable organisation from conducting activities which are not wholly to the carrying on of its main charitable purpose. I do not propose to give examples because this provision is new and difficult cases may arise under it. But I cannot accept the appellant's argument that if the respondent succeeds in this case, it must show that this provision adds nothing to the requirements. The premises must be occupied by the charity. If the use which the charity makes of the premises is directly to facilitate the carrying out of its main charitable purposes, that is, in my view, sufficient to satisfy the requirement that the premises are used for charitable purposes. And that's the test that he draws. So I draw attention to the fact that in the circumstances of this case, he's manifestly rejecting a suggestion that you just look at what goes on in the house, and the exercise he's undertaking is one of understanding the contribution which the house makes to the charitable purposes. I readily accept that he is contemplating a category of use that's outside of the core activity, if I could adopt my Lord Sales's formulation of core and ancillary. It's in that outer core, but in the outer core, one takes a purposive approach of taking the trouble to understand how the use of the property connects with the functions and purposes of the charity. It's not clear why one wouldn't take a similar approach to something that's potentially within the core activity of understanding the relationship of it to the purposes and having regard to the purposes as they exist in the real world, if they exist in an area greater than the hereditaments, but over a multiplicity of premises run by the charity. And the formulation there is at letter E, and that is, as we will see, that is what's picked up on and in a sense adopted and applied in the Oxfam decision. We've then got two supporting speeches from Lord Evershed and Lord Hobson, and I don't propose to take the court through that, save just to identify in Lord Hobson. If I could go to 805, when he comes to the second question, he refers to the approach in the courts below of the Lord Ordinary, who regarded the activities there from an objective standpoint. Accordingly, he held, looking at the actual use to which the subjects were put, that their primary and total use was for residence, and that's rejected by Lord Hobson, a sort of purely objective analysis. And he says, I agree, however, with the view which found favour in the second division, this is at the foot of the page, that once the conclusion is reached that the church is the occupier, the viewpoint of the occupier and not the resident must be taken, and then he analyses what that viewpoint is and gives supporting reference. Now, I don't push that too far, but it is a clue that it's not a purely objective. I mean, my submission is objective and subjective are false dichotomies here, but the point is, the objective analysis of this is a residence was rejected. It was rejected in favour of an exercise of actually taking the trouble to understand how the charity uses the property from the perspective of the charity. Now, there may well be an element of objective judgment in that exercise, properly applied, but the nature of it is an understanding of how the charity uses the premises in the real world, and on these facts, obviously taking account of its activities off the hereditament, outside of the hereditament. And I submit it would be surprising if that was an impermissible approach in terms of trying to understand the use which Nuffield Health makes of its premises, to exclude the fact that it's operating in other premises and that it has an established basis for connecting the various uses and delivering public benefit across the totality of its activities to further its purposes in the public benefit. So I say there is support in that passage, albeit that it's being applied in a different context, and also it's not expressly articulating the way in which public benefit is being approached, but it is, I say, much closer and much more consistent with our approach than the appellant's argument. And then it's worth looking at Lord Guest, because Lord Guest dissents on the second issue, and Lord Guest prefers 907. So you can see the start of the dissent, 807, forgive me, letter D. On the second question, I have more difficulty, and he says the purposes must be exclusive or main use for charitable purposes. The test, in my view, is an objective one, to be decided by answering the question, for what purpose are the premises wholly or mainly used? The answer to that question must be limited to the inquiry of what goes on the premises. So to Lord Guest, it's objective and limited in its focus. And he says that again at 808, letter C. The inquiry is restricted to what actually goes on in the house. Now, that's not the decision of the majority, that is the minority decision. And I say that Merton's case, in other words, you need to ring-fence the activity on the hereditament and analyse only whether, in a counterfactual world, it would meet the public benefit test were it to be applied to it as a freestanding charity. That has strong resonance of just confining the inquiry to the hereditament in question. That is manifestly not the exercise that the House of Lords approved in the majority decision in Glasgow. So, my lords, that takes us to Oxfam. And my lords, the decision in Oxfam concerned charity shops in Birmingham that were selling donated goods. And just to orientate you clearly in how this fits in with the decision in Oxfam and the legislative provision, the decision obviously was that they fell on the wrong side of the line that Lord Cross articulated. So a charity shop selling donated goods was not wholly or mainly used for charitable purposes. There is actually a discussion in here, had the majority of the goods been ones that were handicrafts developed abroad, that outcome would have been different. And the actual result is reversed by Parliament almost immediately in the 1976 Act, which has a deeming provision for charity shops, and that's just to sort of help the court to find that. We don't need to look at it now, but that is at 1229. So a reversal. So that's a reversal which expands the reach of mandatory charitable relief by having a bespoke carve-out for charity shops, but leaves untouched the basic approach as articulated in Oxfam itself. And then so that postdates the Section 40 of the 1967 Act. It comes in as a deeming provision to Section 40, and then when the Local Government Finance Act is enacted in 1988, this is maintained, and you'll find that just the special carve-out is at 699. It's Section 64, subsection 10 of the 1988 Act, which says a hereditament shall be treated as wholly or mainly used for charitable purposes at any time, if at the time it is wholly or mainly used for the sale of goods donated to a charity and proceeds of sale of the goods after any deduction of expenses are applied for the purposes of the charity. So Oxfam is the leading case, but in fact the actual result is reversed by Parliament to expand the relief rather than contract it. So if I could then go to Oxfam itself, which is at 848.
Is it known whether most charity shops had been receiving rates relief prior to the Oxfam case?
I think it said in there that the practice was that I think that it's recorded in there that the practice was that they were, and then there was a decision that came out, which let me just see if I can find it, which led to the production of an opinion that put the matter in doubt, and therefore it was tested. So right. I think the basic thought was originally they thought it was covered, and then the point was. May I find that? I'll find that over.
Yes, don't worry.
I don't immediately have that reference. So in the. May I start with obviously where this goes is Lord Cross articulates a line, and he does so expressly by reference to or applying Glasgow, and there was some discussion of the position of head offices. It's absolutely clear that head offices are on the right side of the line, subject only to an issue about whether if they were mainly used for fundraising they might not be, but if they're used to administer the charity they would get the relief. I'll show my lords the exact point there. But so there, if we think about that in terms of my lord sales core activities and ancillary activities, and then two remote activities, I would surmise that the head office would be placed just at the right part of the wholly ancillary, but not too remote. But obviously the investment in the fundraising is too remote per Lord Cross in Oxfam. But against that background, it's helpful to just look at the way the argument was advanced. And may I show my lords 851? So the rating authority was represented by Mr. Brown Wilkinson QC, as he then was, and you'll see his submissions at 851. And if I could just pick it up at D, a lot of difficulties as regards Section 40 of the 1967 Act flow from a reluctance to give the subsection its obvious meaning. This is obviously the submission. It's clear that there have to be these two requirements: occupation by a charity for charitable purposes, not for any purpose. Any charity to be a charity must be founded for exclusively charitable purposes. If therefore one says of premises that they are occupied by a charity, they must in one sense be occupied for charitable purposes. And then he says this: there are two extreme views of this section, both of which have been rejected by the courts. The first one: the premises must be occupied for charitable purposes, therefore show me the premises which are occupied by a charity, and they must be occupied for charitable purposes. This is inconsistent with the cases cited. So pausing there, that would be, for example, if you're fundraising or if you're collecting in money, you can't just say, I'm a charity, I'm occupying, that's enough. So that extreme is knocked out. But the second extreme, which he says is also rejected and is an extreme view, is look at the activity going on the premises. Closing one's mind to anything else and ask oneself, is that activity per se charitable? Now he rejects that, and he says the correct approach is in Glasgow. Now, we'll see how that pans out when we see Lord Cross's line, but my observation is there is a lot of similarity between the way Merton invites you to approach the critical construction issue and the basis on which it was said was an extreme view which was rejected and not the right approach, which was ring fencing. That's the shades of Lord Guest approach, but it's put in a pithy and helpful way there by Mr. Brown Wilkinson, QC as he then was, and that there's a close correlation between that rejected framework and the way that Merton invite the court to say that public benefit must be approached. So with that in mind, may I then go... I draw attention to that because it accords with how Lord Cross frames the critical issue, and also because of what I say are the correlations between the extreme view number 2 that was disavowed and Merton's case.
Does the case he refers to here, does that assist?
Well, I'm not sure it actually does. I've looked at it, and it's a Northern Ireland case, and it's basically quite close to Glasgow. So it's a Northern Ireland case, which is a bit different because it deals with exclusively for charitable purposes. But the point was it was a boarding school, and the general master's accommodation was held not to satisfy, but the vice principal's office was. But I don't think there's anything in there that particularly illuminates how he drew that proposition, and I would suggest that proposition is drawn really from the rejection of that approach in Lord Guest's speech in Glasgow, rather than necessarily from that. But I did follow that up in case it illuminated exactly where that formulation came from. So that if I could go to the main speech of Lord Cross, which your lordships will recall starts at 857, and he makes his observations in relation to section 40, starting at letter F. It's somewhat curiously worded. No body or trust can be a charity unless its objects are exclusively charitable. This is using premises of which it is in occupation for purposes for which it's entitled to use them and not in breach of trust. It must be using them for some purposes or other purposes of the activity. Yet this subsection clearly contemplates that a charity may be properly using premises which it occupies for purposes which are not charitable purposes of the charity. A line has therefore to be drawn somehow or other between the user of premises for purposes which are charitable purposes of a charity within the meaning of the subsection on the one hand, and their user for purposes which, though purposes of the charity, are not charitable purposes of the charity on the other. Now, my lord, I accept my lord Briggs' observation that formulation actually conflates purposes and activities in a way that makes it more confusing. For present purposes, it's just identifying the need to draw a line, and we'll see that when he does draw the line, he draws it really quite clearly and by reference to Glasgow. But it's no part of my case to say that's correctly framed in terms of the distinction between activities and purposes. There's then some discussion of Oxfam's uses.
What's so extraordinary is that he reminds himself at the very beginning of the paragraph that all the purposes must be charitable.
Yes.
So it's certainly not someone who thinks there can be non-charitable purposes of a charity.
No.
In any wider sense.
No, my lord, I agree, and I suspect it would be illuminated by clarifying that distinction. If I could then pick it up at 860 letter E. The wording of Section 40 of the 1967 Act shows the legislature did not consider that the mere fact that the hereditamate in question is occupied by a charity justifies any relief from rates. That is only justified if the hereditamate is being used for charitable purposes of the charity. So the first question which arises is, what are the charitable purposes of a charity as distinct from its other purposes? The answer must, I think, be those purposes or objects, the pursuit of which makes it a charity. That is to say, in this case, the relief of poverty, suffering and distress. Assuming that to be so, it might be argued that relief from rates could only be granted if the premises in question were being used for the actual giving of relief to those in need. If, for example, those in need came there to receive food, clothing or shelter. But the decision of this House in Glasgow shows that that construction is too narrow. The charitable purposes there was the advancement of religion by the provision of services in a church owned by the trustees, and the question was whether the house belonging to the trustees, of which they were held to be the rateable occupier, but which was used as a residence by the church officer whose duty was to look after the church, was being used by the trustees wholly or mainly for charitable purposes. And then he cites Lord Reed's speech, which we have seen in its entirety, and then he says this at 861, just below letter E. Oxfam therefore is entitled to rating relief in respect of premises which it occupies and which are not being used for the actual relief of poverty or distress, if, to quote Lord Reed, the use which it makes of them is wholly ancillary to or directly facilitates the carrying out of its charitable object, the relief of poverty or distress. One example of such a use would be the head office of Oxfam. So he's clearly placing the head office of Oxfam within that outer category, to use Lord Sales's formulation. But the point here is that he's adopting and applying what Lord Reed says in Glasgow and saying that the head office would be on the right side of the line. He then undertakes a detailed review of the cases, and I will skip over the detail of that and pick it up with where he draws the line, which is at 868, just below letter A. He says, those being the relevant authorities and the rival submissions, where should the line be drawn? And then he accepts that everybody thought it was unsatisfactory to draw a distinction between managing existing trust property and raising money in terms of covenants. And he postulates the choice, and Mr. Gowdy's already taken you to this, but he postulates the choice between A and B, and it's A that he opts, and A is drawing the line so as to exclude from relief for the purposes of getting in, raising or earning money for the charity, as opposed to user for purposes directly related to the achievement of the objects of the charity. And my submission is that formulation there, purposes directly related to the achievement of the objects of the charity, is the pithy characterisation of the type of use which would fall within the category of it. And it might be because it's actually the actual delivery of the objects of the charity as part of a range of activities the charity undertakes for overall public benefit, or it might be because it's ancillary, but it's not a position where all of the flexibility and analysis of approach relates only to the wholly or ancillary. The basic distinction is applying Lord Reed, drawing that line, and that formulation, read together with the earlier passages, suggests that there is an inquisitorial analysis of whether we are concerned with user for purposes directly related to the achievements of the object of the charity. And my submission is, when you look at Mr. Newman's evidence, together with the registration and the uncontested public benefit overall, we are comfortably within that core category, because Merton Abbey is being used for purposes directly related to the achievement of the objects of the charity, namely the advancement of health in the public interest, for public benefit, see our purposes and see the totality of our activities being held to be for public benefit. So I say that drawing the threads together, I should say, you then get the part of Lord Morris's speech that my learned friend Mr. Gowdy has taken you to already, and that's a slightly different formulation at 870 to 871. But in my submission, there's no real distinction. If anything, Lord Morris is formulating quite widely the approach that's taken there. I consider that user for charitable purposes denotes user in the actual carrying out of the charitable purposes. That may include doing something which is a necessary or essential or incidental part of, or which directly facilitates, or which is ancillary to what is being done in the actual carrying out of the charitable purposes. So he's drawing that formulation quite widely, and he's saying what there needs to be is something that's sufficiently close to the execution of the charitable purposes of the charity. Now, I say we are in the inner core here because the hereditaments is being used to deliver, to advance health. And it's being used, there's a complete mischaracterisation to say it's being used to advance health simpliciter, which is what's said by the appellants. It's being used to advance health as part of the objects of the charity of Nuffield Health and as part of a range of coordinated activities which overall are for public benefit. And so therefore it clearly passes Lord Morris's formulation as well as Lord Cross's formulation. But for completeness, it's Lord Cross, which is the majority speech, see Lord Simon, Lord Edmund Davis and Lord Fraser at 872 who expressly agree with him. But for my purposes, nothing turns on any fine
Lord Morris was concurring.
I beg your pardon?
Lord Morris was concurring.
Concurring, yes,
Yeah.
and his observation. Exactly. So forgive me, it's not a minority speech. It's a concurring judgment, not expressly supported. But if and insofar as there's anything turns on the specific reliance on Lord Morris in Mr. Gowdy's submissions, but my main answer to that is I'm comfortably within the broad formulation contemplated by Lord Morris. But secondly, Lord Cross is what gives rise to the obiter dicta arising from Oxfam. So the points drawing the threads together from Glasgow and Oxfam, my points are the analysis needs to understand the use which the charity makes of the hereditament, and as I've submitted, the inquiry can necessarily take into account activities outside the hereditament if they're relevant to understanding how the use of the hereditament relates to the achievement of the objects of the charity. And so therefore I submit that Lord Justice Nugee was right in the observations he made in paragraph 145 and 148. If I could just remind the court of those.
Page.
Sorry, that's page 165, first of all. So he, having cited Oxfam, Lord Justice Nugee says, in the present case, it's not suggested that the use by Nuffield House is such as directly to facilitate the carrying out of its main charitable purposes or is wholly ancillary to them, but it is one of the means by which Nuffield Health carries out those purposes. To my mind, it seems surprising that something which is merely ancillary to or facilitates the carrying out of a charitable purpose should qualify for relief, but the actual carrying out of activities falling within its main purpose should not. And I say that's a correct analysis. It is surprising if there is a inclusive and purposive and wide factual inquiry as to whether something's outside the core, if I can put it that way, but that one puts the blinkers up when one is dealing with a proposition that the charity is using the hereditament to advance its objects for the overall public benefit and consistent with its purposes, which are for the public benefit.
The logical progression of the analysis in Oxfam in particular is the other way around. You start with the main activities, the core purposes, and then you see how far out the facilitation of those allows one to extend the relief.
My lord, precisely. And so if you're in the core, you don't get to the wholly or mainly, but it certainly doesn't mean that you don't get the benefit of the inquisitorial approach to the wholly or mainly, and you have a blinkered approach to whether you're within the core. And so for the purpose of wholly or mainly, you look outside of the hereditament and judge in reality the use the charity makes. But if anybody's saying they're actually using it to advance the charitable purpose, you can't analyse what they're actually doing. You have to analyse it on a counterfactual basis. And if that was all they were doing, would that be would that be charitable in itself per se? In a situation that doesn't resemble the actual use. And my submission is that there's no support for that. And so Lord Justice Nugee is right, and if anything understated in the observations he makes at paragraph.
He's right on the assumption that the provision of those services to full fee-paying members is part of the fulfilment of the charitable purpose.
Yes, and I say that's established in ISC at the two paragraphs, but that's a necessary part of the that is part of the analysis, but that's the conventional understanding. So he's right on that basis, and he obviously says it doesn't make sense to approach public benefits for rating on a different basis. And so, my lord, the other point at 148 is he says. I accept that in neither, so that's at 166, I accept that in neither case was there any consideration of the present point, as in neither case was there a question raised whether the use of the particular hereditament was for public benefit. They are not therefore directly binding on the point, but for the reasons I've given, they seem to be more consistent with Nuffield Health's position than Merton's. Both cases suggest that the line is drawn between the charity using the premises directly to further its charitable work, or, in other words, a functional use, and using the premises indirectly to support its work by getting in, raising or earning money and investment or business use. Or, to put it another way, the relevant question is whether the charity is using the hereditament for its charitable purposes, not whether the activity carried on at the hereditament would qualify as a charitable activity in its own right. And that's the point that I was making. And I submit that Lord Justice Nugee was right to so find. And just in case it helps, at 128, that's the paragraph number, the page number is at 161. Lord Justice Nugee, in the last sentence of that paragraph, 128, says, when he refers to the existing authorities, he said, what made the use of the premises lawful for each charity was that holding assets and turning them to account was a means of raising fund which supports its charitable work. That's the wrong side of the line. But the use of the premises was not itself part of that work. And that's quite a nice, pithy formulation. Was the use of the premises part of the work of the charity? And I appreciate that's not the test that comes from the House of Lords authorities, but it's a pithy formulation that's consistent with them, properly understood. And if we think about that here, is the work at Merton Abbey, is the activity at Merton Abbey part of the work of Nuffield Health? The answer is obvious when you read Mr. Newman's evidence.
Yes, I was wondering actually whether the point made at the end of paragraph 148 on page 166, again, in a sense, might be put even more strongly than Lord Justice Nugee put it. I was just looking back at the text of section 43, subsection 6 on page 680. It says, applies where the ratepayer is a charity, or trustees for a charity, and the hereditament is wholly or mainly used for charitable purposes, brackets whether of that charity or of that and other charities. So a purpose is a purpose of someone, and we're told it's the purpose of the charity in a simple case, or you can add together other charities. So one might say that actually does take you quite a long way towards saying it's not some sort of counterfactually constructed purpose that a charity might have if it thought about whether it could carry on a single hereditament charitable activity, but the purposes it actually has.
Yes.
In using that hereditament.
I strongly support that, and that's actually, one goes back to the beginning of where Lord 130 and 130 to 138, where Lord Justice Nugee unpacks the statutory construction. That's where he sort of shows his reasoning on the construction to move from what he records as his instinctive view against that to seeing that that's the only way really, or that's the better way of reading the statute, because thought about like that, the choice is either it's charitable purposes, i.e. a real-world inquiry about what's actually going on, or some notional self-contained inquiry where there's no hint of that in the existing authorities, and there's no support for that from the bald proposition that you assess the use of the hereditament. Yes, you do, but that begs the question, how do you do it? And you do it in the real world based on the evidence and based on an inquiry into the relationship between the use and the purposes.
Yes, I mean, otherwise you have to construct a purpose of the charity which isn't its purpose.
Yes. Yes.
And the hypothetical, sort of one-site charity hypothetical, begs the question how, if that was its only site, it would carry on it will fulfill its purposes there while remaining a charity.
Yes.
Yes.
That's where there may be some further thought, but for the multi as to how that then applies. But my submission on that is that wouldn't justify inserting a public benefit inquiry, because that would be something that would be would be covered by the Charity Commission. But what the main instruction point here is as we've just discussed, is whether one brings in an inquiry that's a real-world inquiry on our approach, or a counterfactual inquiry on the appellant's approach.
Well, Mr. Kinsey, I think we're running up against the bell.
We've made rather good progress based on where I am, so I suspect I might be another half an hour tomorrow, if that's okay.
And then we'll hear you in reply on the first issue.
Yes, Lord.
Mr. Gowdy, before we see where we go from there. Thank you. 10:30 tomorrow.